Hey, welcome back, everyone. Welcome to our final segment of our two-day Bridging the Gap CLE program. Our next program topic is a primer on starting a practice in New York. Joining us this afternoon, we are very pleased to have Cliff Ennico. He is considered to be one of America's leading experts in the legal and tax problems facing entrepreneurs and privately owned businesses. A native of Yonkers, New York, he's best known as the former host of Money Hunt, which was a fast-paced reality TV show for entrepreneurs that aired on PBS nationwide from 1994 to 2003. His weekly syndicated newspaper column, Succeeding in Your Business, is known as the Ann Landers of the business world, appears in dozens of major newspapers and business websites throughout the world. He also hosts his own small business legal channel on YouTube, he's also a frequent contributor to Entrepreneur and other small business magazines. He is the author of several books on entrepreneurship and small business management, including the Small Business Survival Guide. He also speaks nationwide on the legal and tax issues facing early stage startups. His book, Crowdfunding Handbook, advises small businesses and early stage companies on the benefits and risks of launching a crowdfunded offering under the Securities Act. He is currently working on books that impact technology and capital raising process for technology startups. He's represented thousands of entrepreneurial companies and small businesses during his career. He is a frequent speaker and lecturer for the New York State Bar. He's also the chair of the Bar Association's Starting a Practice Full Day CLE, which is now 2 half days. We are very pleased that he's here with us to close out our two-day Bridging the Gap program. Without further ado, please welcome Cliff Ennico.
Thank you, Kathy. I have to say, I have to blush every time that Kathy gives me that introduction. I mean, I listen to all this and I say, did I have time to have a life during all of this? I mean, all this stuff that I've been doing for the last 40 some odd years. Hard to believe, but I've actually been a lawyer now for 42 years. And for 41 of those years, I have been doing programs for the New York State Bar Association. I know some of the very early ones were in Dutch. I mean, just so you know, that's how far back I go. There are a couple of things in that introduction, though, that are important. And I think the most important thing is I work primarily with entrepreneurs. That is my practice. I don't like to put a label on myself, but if you want to call myself a business or a corporate lawyer, that is basically what I am. But with a particular focus on entrepreneurs and startups, I am a startup lawyer. And when you are starting a practice of your own, and I know some of you, many of you in this program are planning to do that, you are an entrepreneur. That is the most important thing that I can say in the next hour and a half. You are an entrepreneur, and just like all of my clients, you will have a lot of the same challenges that a lot of my entrepreneurial clients have. I mean, you are in a profession, in a highly regulated profession, but you are also an entrepreneurial business. And like any entrepreneurial business, you need a business plan. So what I want to do in the next hour and a half that we have together until 4:30, I think is when I'm due to stop here. We're going to talk about what a business plan for a solo or small practice law firm or law practice looks like. For those of you who are interested, Kathy mentioned it in her introduction. I do chair a 2-day program on starting a solo practice for the State Bar. We've already done session 1 just earlier this month, which is now available on archive. The second half of the program, which is going to talk more about the operations and management of a startup or small law office in New York. That's going to be on Tuesday, June the 7th. Half-day program from 9 a.m. until 2 p.m. So for those of you who have time and who need some additional CLE credits, that would be an excellent program for you to look at. We really drill down on what you need to do to run a successful law practice as a business in New York. So without any further ado, so what does a business plan for a solo practice look like? I'm a solo practitioner. I've been a lawyer for 42 years. For 26 of those years, I have been practicing as a solo out of my spare bedroom, which you see here in the background. You are looking at the law offices of Clifford R. Ennico right now. I have not left this room in 26 years. You should be aware of this. I've actually been practicing for 26 years the way all of you have been practicing since COVID. I am something of a pioneer in the field of the home office practice of law here. when you're starting, so some of the stuff I'm going to be talking about is the stuff that I've learned in the course of 26 years of practicing law out of the spare bedroom and practicing virtually. There are six big questions that you have to answer when you're starting a solo practice. Number one, what will I practice? What type of law am I going to be doing? What kind of clients do I want to attract? This is sort of a key question, and some of you may think you know the answer already, but I assure you that in most cases you have to do some more thinking about that. You shouldn't just say, "Oh, well, I'm a real estate lawyer. I can skip this session. I know what I am." Not that may not necessarily be the correct answer. So we're going to talk about that. Secondly, we're going to talk a little bit about the differences between a home office and a real office, an actual office that you go to. As the pandemic lifts now, more and more of us are thinking about whether or not we want to return to an office environment or not. Spend a few minutes talking about that. How you set yourself up legally, should you be a corporation, LLC, or sole proprietor? How will you manage your practice so that you make money? Very important. This is a business like any other. And if you're doing something that is a lot of fun but doesn't make money, we have a name for that. We call it a hobby. A business makes money. How do you make money and how do you manage your practice so that you don't end up working 90 hours a week for $30,000 a year pre-tax? How much will you charge your clients? Billing and collection, one of my favorite topics. Hopefully we'll get a few minutes at least to talk about that. I have some very particular rules. And last but not least, how will you get the word out? How do you market your practice? In the Starting a Solo Practice program, the two-part program I do for NISBA, we have a whole couple of hours that we spend on marketing. That marketing is the key to success in any small business. Take it from someone who has worked, as Kathy says, for thousands of small businesses and entrepreneurial startups. Marketing is the key to success when you run a small business. When you're working for a big firm, you can have a nice career indeed and not have to know anything about how to sell clients. In a small practice, you do not have that luxury. Marketing is job number one. If you are not spending at least 25% of your time on marketing related activities, sooner or later, the phone stops ringing, the emails stop coming in your inbox, and you fail. Failure is a guarantee for any small business that doesn't know how to market itself. So let's walk through these six things really quickly. What will you practice? Okay. This is a very important thing. This is probably one of the most fundamental decisions you make when you're starting a small practice. What am I going to do? What kind of law am I going to practice? What kind of clients am I going to serve? Every law firm is a service business. And as Bob Dylan once very correctly sang, you have to serve somebody. Okay, who are those people? Well, there are four basic strategies that you adopt when you're thinking of starting a practice from scratch. Number one is to stick with what you know and don't venture outside the box. Take on anything and everything that walks in the door and has a pulse. Build a reputation for 2 or 3 highly desirable practice areas and let the market tell you what you should be. Then specialize in a certain type of client and become a generalist for that client. Those are the 4 basic strategies that most solo small lawyers adopt when they're starting a practice. Let's walk through each one. Staying inside the box, okay? I'm a real estate lawyer. I do real estate. I do closings. I do zoning. I do whatever. Okay. What's good about this strategy, your malpractice insurer will adore you. When you do your malpractice insurance application, there's that section where they give you 50 different areas of law and you have to put down what percentage of your practice. If you put 100% in one of those boxes, your malpractice insurer will adore you. It's also easier to describe what you do at cocktail parties and social occasions. So what do you do, Cliff? What type of law do you? I'm a real estate lawyer. Okay. Easy to do. People ask me what I do for a living. My answer is, do you have an hour? It's a little tricky. You will keep all of your hair well into old age. Obviously, this is not the path that I myself have followed. There are disadvantages, though. It may prevent you from growing unless your specialty is in great demand. There are a lot of specialties within the law that, frankly, are due to be extincted in the next 5 to 10 years. There's no secret. We'll talk about a little bit about that as we get closer to the end of the program. I'm going to hopefully, since I'm the last speaker you're going to be hearing today, I'm going to try to give you a little bit of some homely, grandfatherly advice about what you should be doing for the next 40 years of your life, and hopefully you'll end up looking a lot better than I do today. but staying inside the box is really not a very dynamic way to grow your practice. You will end up making other attorneys wealthy. When you stick too closely when you draw too closely within the lines, you end up referring a lot of business to other attorneys and making them rich, and potentially losing those clients. They may leave you vulnerable to sudden market changes and economic swings that will render certain practice areas obsolete or undesirable. And of course, but I'm a realist. I mean, when you're first starting out, you may not have a box to stay into. You may not have the luxury of saying, well, I'm just going to do real estate. If the first client comes in and says, I have an accident case, that's what you're going to do. That's just the reality of a solo practice. What about taking on everything that moves? Every client that comes in, hey, Cliff, I want to do an oil and gas deal. Yep, I'm there. Okay, what are the advantages and disadvantages of that? Well, it guarantees that you will at least have some business. I mean, sooner or later, if you're a lawyer, if you go out there, sooner or later you will find a client. I mean, it's one of the reasons why people become lawyers. Lawyers do not starve. I looked at a number of alternative careers when I was a young person, and the biggest attraction of the law is, even if you're a mediocre lawyer practicing in Horseheads, New York, you still make a decent living. You don't have to be a superstar in this profession to make a decent living. That's I guess it's one of the weird advantages of being a lawyer. People go to law school really to hedge their downside. If you really want to, I was attracted by journalism as a young person. And the trouble with journalism, though, is that if you're not a top-notch columnist or media superstar, you starve. The people who write for your hometown newspaper are barely making a living wage. They probably double time as a barista at the local Starbucks. The nice thing about being a lawyer is you don't have to do that. It also may be the only practice alternative when you're just starting out. If you don't have a lot of experience with particular specialties, you hang out your shingle and you see what comes in. But there's a serious malpractice risk here. No one can stay on top of all developments in 5 or more practice areas. I don't care how many CLE programs you attend. No one can stay on top. Sooner or later, you're risking your duty of competence under Rule 1.1 of the Rules of Ethics. Your malpractice insurance may not cover everything that you want to do. Instead of putting 100% in one of those boxes, you're going to put 2% in all 50 of those boxes. Your malpractice insurer is not going to like that. They're going to think that you're spreading yourself too thin. Another issue, though, is by spreading yourself too thin, you may have trouble developing a reputation for expertise in a certain field. My father used to say this all the time: Cliff, you could be so well-rounded that there's no point to you. That's a very good quote. If you're doing everything to anybody, sooner or later, you're not doing anything for anybody. At some point, you have to have something that sets you apart from the pack and that gives you a competitive advantage. Doing everything for everybody is not going to get you there. So what about letting the market decide? Okay, well, I'm going to, I'll try a couple of things, but then the minute I see that there's a strong demand for a certain thing, that's what I'm going to do. Okay, more likely that you will get work on a regular basis because, by definition, this is an area that's in demand. There probably will be less competition. Meaning you can charge more for your services. Whenever you're in a market where there are a few other lawyers doing the same thing that you're doing, your prices can be higher, because you don't have the heavy competition that keeps them down. You may get referrals from other lawyers who are staying in their boxes. Patent and trademark lawyers always attend bar association functions. Why? Because they tend to get a lot of their referrals from other less specialized attorneys, and they want to know as many of those people as they possibly can. You can also develop a reputation for cutting edge legal work before other lawyers do. To some extent, I do this in my practice. Whenever I hear about a certain technology development or something going on, I try to become an expert on it as quickly as I can so that I can go out there and say, hey, you want somebody who wants to speak about, the metaverse and, whatever its impact on your law practice? Well, I can talk about that if you want me to. That's kind of how I market myself. I kind of say, well, here's this thing you've read about in the papers. Now, here's some of the legal issues that come out of that and what you may want to think about doing. That's a great way to grow your practice, by the way. We'll talk about that more when we do the marketing stuff. But there are disadvantages too. This is a stressful way to make a living because you're constantly in learning mode. The law book publishers will love you because you're going to be buying everything they've got. Just about your basement is going to look a lot like mine. Let me tell you, when you've written 17 law books, all of which are being supplemented 2 or 3 times a year, your basement tends to look a certain way. Okay. It kind of looks like an Amazon warehouse. In fact, you're going to help me out with that, by the way, a little bit later. I'm actually going to give away a couple of my books a little bit later on in the program. So heads up. This is one of the things I'm very grateful to Kathy for. She actually lets me do this, give away a couple of my books so that I can see the floor in my basement eventually. But there may be, keep in mind too, there may be a good reason why local attorneys avoid certain specialties, even if they are in demand. Maybe they're just too stressful. They thought, they don't make enough money for you. There may be some good reasons why, people are demanding stuff, but attorneys are reluctant to hand it on. Also, if you are developing more than one specialty, there may not be synergy between them. If you are doing internet law and trusts and estates, your psychological profile is very, very interesting to me. Those are not only very different areas of the law; they require very different brains to do those two different things. So how is the internet practice going to get you trust and estates work and vice versa? I don't see any synergy there. If you're going to do multiple things, there should be some synergy where one thing feeds the other. Oh, you're starting a business. Okay, do you need a trademark done? Do you need this? That's the kind of thing that you want to try to develop. Look for if you're going to follow this path, look for practice areas that are in demand, that are cutting edge or otherwise haven't saturated the market, that can generate a decent profit margin for you and that you can easily market to without great expense. Ideally, that's how you pick a practice area that is marketable and where the customers are going to the clients are going to tell you what to do. These are the four things that you look for. So let's talk about the last of these four strategies now, which is specializing in target clients. This is the path that I have more or less followed. I am not a specialist. I practice in 36 different areas of the law, and I can tell you a little later on why I know it's exactly 36 areas of the law, but I don't know everything about those 36 areas of the law, and I don't need to. I represent small businesses and people who are starting entrepreneurial companies, and that's all I care about. That is my target clientele. Within that, I do just about anything that they need done. My tagline, if you go to my website at cliffennico.com, says a Wall Street lawyer for your small or growing business. That's my tagline, and that is what I am. I am your general counsel until such time as you outgrow me and you need more specialized legal services. And if you need more specialized services, I'll help you find them. I'm the internist who, if you have a headache, you come in and I'm the one who's going to make the decision whether you just need two aspirins or whether you have to see a brain surgeon, a neurologist. I'm the one who's going to make that decision here. I'm your gateway, your attorney. That's kind of how I work with a lot of my clients. And that's great because I don't have to know everything about 36 areas of the law. When Obamacare came out, Affordable Care Act came out in 2009, I didn't have to read all 600 pages of those regulations. I didn't have to know anything about gold-plated insurance policies because none of my clients were offering gold-plated insurance policies to their employees. The one thing they did have to know about, though, and if you remember in the early days of Obamacare, there was an employer mandate. If you had more than 30 full-time equivalent employees, quote unquote, you had to offer health insurance to those employees. And a lot of my clients have part-timers, they have independent contractors, virtual economy people that they work with, and they were paranoid about not going over that 30 full-time equivalent employee limit. So knowing how to calculate that limit was essential. I had to know that because that's what all my clients needed to know about. But there were a lot of aspects of Obamacare that I didn't have to know anything about, so I didn't have to know those things. So that's kind of how, I'm a generalist. I'm one of the last generalists probably in the American legal profession, but I'm not really a generalist because I'm focused, though I focus those 36 areas of the law on just what my clients need to know. But there are disadvantages. If there are not enough target clients in your area, you may have to relocate or engage in a multi-jurisdictional practice. One of the things I sweated when I first set up my practice is is there enough entrepreneurial activity in New England? Should I be in California? Or if I were doing it today, if I were starting out, should I be in Florida or Texas? Because that's where a lot of entrepreneurial activity is. The infrastructure for entrepreneurs in Texas is unbelievable. It is much more developed than it is in the northeastern United States. Here in the Northeast, we don't coddle our entrepreneurs the way other parts of the country do, and it's something you have to think about. You also may be vulnerable to market, technology, and economic swings that disproportionately impact your clients. When I was first starting out in 1980, representing book publishers would be an excellent example of basing a practice on target clients. Well, how many of you here would base your today would base your practice on book publishers, hardcover book publishers, textbook publishers? You're not. It's all going digital now. So that's the thing. If you're going to follow this path, identify a client that is common in your area and provide a wide range of services for that client, with some exceptions. I don't do patent work. I don't do litigation of any kind. But short of that, I'll do anything a client wants. Just be careful and don't end up focusing on clients who don't know what they're doing and have no money. Now, I will tell you, this is a huge underserved demographic, and especially in the New York area, in New York State. There are a lot of these people out there. They're very easy to find, but you will not make a living from these people. They are time vampires, and they will make you old before your time. Just be careful about dealing with people who don't know what they're doing, and the end is very important, have no money. Okay. Here are some other client-centric strategies you can follow. You can follow business types. So like I do, early stage technology companies, specific industries such as construction. I know a lot of attorneys who just do nothing but work with construction companies. They do very well. Underserved ethnic or religious groups. A lot of immigrant communities here in the United States, and a lot of them are settling in New York, in the New York area, are underserved by attorneys. They have trouble finding attorneys to help them with issues. So if you speak a little Arabic, or if you're willing to hire a couple of Muslim employees, targeting the Hispanic community, Muslim communities, can be extremely rewarding for you, because these people have trouble finding attorneys. Economic status, high net worth. If you're a trust and estates attorney, you're not going to make a lot of money doing blue collar wills. You're going to be making your money for presenting high net worth individuals who need sophisticated tax and estate planning. Most T&E attorneys that I knew don't make their money doing wills. They make their money administering estates and doing the tax forms, the estate tax forms, the 706s, and the income tax forms that the estates need done until they clear probate. Clients who themselves specialize in target clients. So if you are a real estate lawyer, I hate to dump on real estate lawyers, by the way. Please, I'm sure there are some real estate lawyers here on the call. Please do not be offended. But you can be a successful real estate lawyer specializing in residential real estate. You can also specialize in commercial real estate investors. As someone once said, you can make money selling BMWs, you can make money selling Volkswagens, but you can't make a lot of money selling both. You kind of have to know which end of the market you're at. Okay. Should you take on clients? We talked a little bit about multi-jurisdictional practice, and this isn't an ethics segment, but I just want to make this a little simplified here. Should you take on clients in other states sooner or later, especially when you work with the kind of clientele that I represent? One of your clients, usually a key client, moves to another state. What do you do in a situation like that? Must you pick up stakes and follow them wherever they are going? Well, here's the thing. Whenever you're looking at clients in another state, it's a two-prong analysis that you have to go through. Okay. Question number one, you do have to look at the other state and find out how they define the practice of law. In New York, Model Rule 5.5, that's the section that deals with multi-jurisdictional practice says a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction. Translated into English, if what you want to do in the other state constitutes the practice of law that can only be done by licensed attorneys in that state, you cannot do it. Now, that's the bad news. The good news is, however, and this is something that I'm actually writing an article on right now. I'm actually doing a 50-state survey, which I will finish someday. I've been talking about this now for 2 years. I work on it when I don't have time to do anything else. But defining how each state defines the practice of law, and it's fascinating. The one universal constant is representing clients in court. You cannot represent clients in court in another state without being a licensed attorney in that state. Okay. But once you get beyond litigation and courtroom practice, the rules are all over the place. Some states say you have to be an attorney to draft wills or other testamentary instruments. Other states say you don't have to be. Some states say you have to be an attorney to give a legal opinion to a bank or financial institution, like an SBA loan. Other states say you don't have to. It's amazing. It's all over the place. Most of what I do for clients technically is not the practice of law at all. Forming corporations or LLCs, accountants do them all the time for their clients, and sometimes they do a better job than we do because they know the tax rules better than we do. Helping clients do transactions. A lot of investment bankers do that kind of. You don't have to be a lawyer to do a lot of the kind of stuff that I do, which is fascinating. So I have a bit more flexibility in working in other states because what I do there is not likely to be considered the practice of law. That's the first prong. The second prong is a little bit more subjective, and that is, are you willing to undertake the effort to learn the law of that state? Whenever you are practicing law in another state, you are held to the same level of competence and malpractice liability as an attorney who is licensed in that state. So if I have a client that moves to California, I have a duty of competence to become familiar with some of the crazy statutes California has governing businesses. And they got some doozies out there. I'll tell you right now, there are sections of the California Civil Code that do not, and Business and Professions Code that do not exist in any other state of the union. That you have to become familiar with. Some of you know that they have a consumer privacy law for use of data on the internet that parallels the European GDPR. Other states are starting to follow California's lead now. So if you're going to practice in another state, you have a duty to become competent in the laws of that state. Maybe join one of the local bar associations, take some of their CLE programs like this one, because those are the two steps. Before you represent a client in another state, find out, first of all, how that other state defines the practice of law, and then ask yourself, are you willing to make the time and effort to learn enough about the laws of that state to be competent? And you may consider at some point taking the bar exam. I mean, so many of my clients right now are going to Florida. I'm actually thinking of taking the Florida bar, 42 years after I took the New York bar, because there's no correspondence between the two. So anyway, okay, let's shift gears now. Let's talk about home offices versus real offices. So that all we've been talking about up until this point is practice mix. What type of law are you going to practice? And as you can see, it's a little bit more complicated than just saying, well, I've always been a real estate lawyer. That's what I should continue doing. It's more of a complicated analysis. You should look at each of these 4 strategies and ask yourself what's right for you. Okay. Home office versus real office. Okay. For certain types of practice, a real office is unavoidable. I mean, so for example, if I'm looking to plan to do some estate planning and I'm putting all of my family's wealth into your hands, I don't want to go to a house in the suburbs and see you playing Frisbee with your dog as I get out of my car. There's a certain image that I expect of a trust and estates lawyer. I expect to go into an office that's been there for 1,000 years, as the Dutch ran New York. I want to see dust on the books. I want to see, classic prints on the wall. I don't want to see a lot of modern art or funky rock posters. I want a practice that screams solid, not going anywhere, will always be there for you. That's the image that people expect. And there's, by the way, there's some research that psychological research that where they've actually interviewed people and done questionnaires to show people feel more comfortable with trust and estates lawyers who look solid and look that they've always been there. Litigation is the same thing. It's very hard to do a home-based practice and stay on top of a court calendar, even with Zoom meetings and Zoom depositions. Keep in mind, if you New York has this law, judiciary law number 470. If you reside out of state, like I do in Connecticut, you must maintain a physical office within the state of New York where you can see clients. So, if you are out of state, if you're in another state and you plan to, practice in New York, you have to have at least some place where you can meet, and it has to be a physical location. It can't be a PO box or a UPS store. It can be a home office. You can have clients in your home, or if you have a pied-à-terre in Manhattan or something, you can meet them there, but it has to be a physical location. This is hopefully going to change in the near future. I know the State Bar has a committee that's looking into overturning this law, which has been around since 1909. But right now that's a little something that New York does that kind of limits your flexibility here. Most states do not have this requirement. You do not have to have a physical office in order to practice in another state. But there are some other reasons you may not be able to work from home. Your local zoning regulations may not let you. Your nosy neighbors may not let you. Your spouse or significant other may not let you. And well, it's also, I will tell you something, working out of the home requires incredible self-discipline. It does. And those of you who are working out of the house or who are dividing your time between home and office right now, you know exactly what I'm talking about here. It's not for sissies. You have to be very disciplined and be a very good time manager. And there are some people who simply can't do it. They need to have that break between their personal life and their work life. And if that's the case, you will need to do a home office. Okay, I said I was going to give away some books, and here's how I do it. I do it in the form of pop quizzes, and I've got 3 of them in this segment. Here's how it works. If you think you know the answer to the question, send me an email. Do not respond in the chat room. Please do not do that. Kathy will not know what to do with these things. Do not send me an email. I left my email address right there. And don't worry, you're not signing up for anything. I keep these strictly confidential. When the session's over and I give away my books, I destroy this stuff. You're not signing up for anything, so don't worry about that. And the way it works is the person who comes up with the first and best answer to each question gets the book. Okay, that's how it works out. I get to pick the book you get, although I'll ask you some questions about your practice, and I'll try to find the best fit for what you do. So here's my quiz number 1. Wolfgang Amadeus Mozart. You all know who he was, right? The composer, an entrepreneur who worked from a home office. This is how I define him. Wrote dozens of concertos for virtually every instrument of the orchestra except one. He never wrote a concerto for the cello. Why? Okay, for those of you who are not classical music freaks, a concerto is a form of music with a solo instrument and an orchestra, and the two talk to each other. The solo instrument develops the theme, the orchestra takes over, and they kind of have a dialogue back and forth. And there have been concertos written for virtually every instrument of the orchestra. Mozart was a champion concerto composer. He wrote 27 concertos for the piano forte of his time. He wrote 7 concertos for the violin. He wrote 4 concertos for the French horn, which was an exotic instrument. It was just being added to the orchestra during his lifetime, but he never wrote a concerto for the cello. And this mystifies a lot of music scholars, because we know the cello was one of the instruments he knew how to play. From his correspondence, we know he loved the cello. It's the instrument of the orchestra that most closely approximates the range of the human voice. He loved the cello, but he never wrote a cello concerto. What happened here? Did Mozart just wimp out on this stuff? Now, the key to answering this question is to look to see how I define him. I'm not defining Mozart as a composer or as a musical genius. I'm defining him as an entrepreneur who worked from a home office, which he did. If you view Mozart that way, the answer to the question is fairly straightforward. So answer it correctly, get me the first and best answer, and you will get one of my books to weigh down your any piles of any. They make great doorstops, by the way. I'll tell you that. Okay, so should you work from a home office or a real office? Well, to me, the big question is, should you see clients and customers in your home office? And there's a very simple answer to this. The answer is no. Okay. Or G, why? Okay, seeing clients in your home makes you more visible to your neighbors and community. And when you are doing something out of the house that makes you visible to your neighbors, if neighbors are aware and they notice what you're doing, that's when you have to worry about things like your local zoning laws. I'll be more specific in a minute. There's also an increased risk of slip and fall and dog bite type liability. If you have a very friendly Rottweiler that loves greeting everybody who comes to the door, and your client, shows up and is deathly afraid of large dogs, he's going to have a heart attack on your doorstep. You're going to have an issue there. Not all clients and customers are nice people. Household items may go missing. Your spouse, jewelry, especially if you leave them hanging around your living room while you're speaking to somebody else on the phone. Certain items of value may go missing. Your spouse or significant other will not want people traipsing through your house. And also, too, do you really want your clients to see how you live or know where you live? I mean, those of you who do criminal defense work, do you really want a lot of your clients to know where you live? I'm not sure the answer is yes. The key to working out of a home office. Now, I've been doing this now for 26 years. I've been practicing out of my spirit business. Most of my neighbors don't even know that I practice out of the house. I am completely invisible to them because this is the key. If the local kids can't play basketball because they're too busy dodging UPS trucks going to and from your home office, sooner or later, the neighbors are going to rat you out. Every town and city in the United States that I'm aware of has a zoning law. One of the principal rules of zoning is you can't have a business in a residential district, but there are literally millions of home offices in the United States today, and nobody is going to jail for doing this. Why? Because most people maintain invisibility. As long as the neighbors don't care about what you're doing, you will never have a problem with your local zoning authority. It's only when you become so open and notorious that the neighbors are worried about the quality of life or the value of their property declining. That's when they're going to rat you out to the local zoning police, and you're going to have to meet with some local government officials who are going to shut you down. Okay. How do you achieve invisibility? Don't use your home address for business purposes. Rent a UPS store. The UPS stores are wonderful, by the way, for people who work out of the home. Now, those of you know UPS stores, that's where you send packages by UPS, but a lot of people don't know. They also have a private mailbox service. You can rent a mailbox there where you get an actual street address. You're not P.O. Box 123. You're 123 Main Street, suite number 456. And it's in a commercial zone. It's perfectly, never have a problem with zoning there. All your mail goes there. They also have copying machines. They do bulk scanning, bulk shredding. They do a lot of the stuff that you don't want to spend money on equipment to do. The UPS stores are a wonderful resource. When you're starting a home-based law practice or any other kind of home-based business, get to know your local UPS store. They have incredible resources. Also, it gets you out of the house at least twice a day. I joke about not leaving the house, not leaving my spare bedroom except for meals. But when you have a mailbox at a UPS store, you have to go there at least twice a day, once in the morning to drop off your outgoing mail and once in the afternoon to pick up the stuff that comes in. Make sure, and those of you who see my address on my website or, in my stationery, the 2490 Black Rock Turnpike, number 354, that's a UPS store address. For those situations in which you need to meet with clients, find another law firm in town that's willing to let you use their conference room. I've got 2 local firms here in Fairfield, Connecticut, that will let me use their conference room if I need them to do a big closing or something like that. And of course, I pay them a little something. I refer business to them as well. But most of them, as a professional courtesy, as long as you don't abuse it, will let you use their space. Libraries also have conference rooms now that they can rent out, although they're not always as private as you'd like them to be. See clients at their offices whenever possible or in a neutral location. When I was first practicing, I was known as the diner lawyer of Fairfield County. I met my clients in diners. Diners are wonderful because you can get any kind of food you want, even if it's not on the menu. They'll make it for you. And usually, unless you hit them at busy times like Saturday and Sunday morning. If you go there and like in the middle of the day on a Tuesday, they'll let you sit for a couple of hours, and as long as you keep refilling the coffee or the Diet Coke, they'll let you sit there for as long as you want. They won't hassle you. They're not looking to turn the tables over quickly. So they're great places to meet clients. Just be careful about your waistline. If you do decide to become a diner lawyer, be sure that you have a gym membership and be strict about it. Otherwise, you end up looking like this. Okay. Avoid noises, especially at night. Bright lights. Don't put a sign up, a neon sign in your front lawn saying, Cliff Ennico, attorney, 1-800, winning lawyer. Don't do stuff like that. It's sleazy, it's cheap, and also too, it'll tick off your neighbors. Okay. Shifting gears now, let's talk about how you set up your home office. Either should you do an LLC, a PC, PLLC, or neither. Okay. Getting a little bit personal here. I do not have an LLC or a PC for my law practice because it's just me. I'm an extreme solo. I don't have staff. I don't have paralegals. I don't have virtual assistants. I don't even have a dog or a cat. It's just me and my PC. What you see is what I've got here. So I don't really have it. Now, why is that? Well, you can certainly form a PC or an LLC in New York to engage in the practice of law, but you have to be aware that in New York, just like in every other state, a lawyer is not allowed to limit his or her liability for malpractice by setting up a corporation or LLC. And here are the statutes in New York. There's one in the BCL for corporations and one in the LLC law for LLCs. It's exactly the same language. You cannot limit your liability for your own malpractice by forming a PC. Now, don't get me wrong. If I were ever to bring on a partner, especially a partner in an area of the law that I'm not familiar with, the first thing I would do is form a PC or a PLLC. Why? Because when you have partners, you are not only liable for your own malpractice, you're liable for theirs as well. Even if you didn't contribute at all to the errors or omissions that they made, or their screw-ups in plain English, you are on the hook. So you do not want to you want to limit your liability to just your screw ups, not theirs. And that's what the PC or the PLLC gives you. It does. But when it's just you, forming a PC or an LLC doesn't really do a whole lot for you. I would rather spend the money that I would spend forming a PC or an LLC, I would much rather spend on a drop dead policy of malpractice insurance, because a plaintiff is much more likely to go after an insurance policy than to go after somebody's house. That's just, if you're a litigator, you know what I'm talking about there. It's much easier to go after an insurance company than to try to get a lien on somebody's personal property. But it may be a good idea. There are reasons why you should form a PC or an LLC, even if it's just you. You may be engaged in other non-legal activities, and the rules of ethics require that you maintain, if you do that, the rules of ethics require that you maintain a clear separation between them. Forming a PC or an LLC for your law practice would accomplish that. If you plan to bring on partners in the next year or 2 years, you may also want to do it for optical reasons. Let's say you have a name that is totally unpronounceable. And so, using your name as the firm name probably isn't going to get you a whole lot of business because no one can remember how to spell it. To some extent, I have this problem. A lot of people don't have trouble with the name Ennico, especially when it's not sitting there, staring them in the face. So what a lot of attorneys do who have unusual names is they'll create a trade name, Cliff the LLC guy, and go out as cliffthellcguy.com. And the rules of ethics do allow that, by the way. If you look at the New York State Bar is a great place to be, because the New York State ethics opinions, in New York, we have more ethics opinions on how to name a law firm than any other state in the union. If you go to NYSBA.org and you go into the resources section and you go for where the ethics opinions are, you will see that every third or fourth ethics opinion has to do with how you coming up with a name for a law firm that does not violate the rules on attorney advertising. We have an incredible body of law in New York on this topic. So take advantage of it. You do not have to be, Clifford R. Ennico attorney law. You can be Cliff the LLC guy if that's, the brand image that you want to create, subject to certain rules and limitations. Okay. So let's now talk about managing a practice. How do you manage a practice to make money? Okay, now I've given you some very, very good resources here. Okay, I've given you some resources. There are, you know, I didn't give you a lot of cases and statutes and stuff like that. I gave you outlines and checklists. I used to do this course a number of years ago with a gentleman named Gary Fiebert. He is he's now retired, but he was a management consultant for many years that works specifically with solo attorneys and small law offices in the New York tri-state area. And he and I developed this business plan checklist for all the things you need to think about. It's about 6 or 7 pages long. You know, so I think it's a PDF file. Print it out. I mean, it goes into a lot more detail than I'm going to be able to do today about the things you have to put together, you know, in order to do a financial plan for a you know, for a solo practice. You know, budgeting. Okay, whenever you have a small business, this is one of the most difficult lessons I've learned in working with small businesses for 42 years. Big business is all about earnings and profits. Small businesses are all about cash flow. You know, generating revenue each month. They're all about the P&L, generating revenue each month. You know, managing costs and then living on whatever is left over. When you have a solo practice, that's what you're doing. You need to know your costs cold. You need to know exactly how much money you're going to spend each month on rent, on, you know, overhead, on, you know, food, on everything. How much do you need to live on each month? You got to know those costs, and you got to know them cold. And you need to know how much revenue you need on a monthly basis to be able to cover those costs. When you are making enough money that you can cover your operating costs each month, you are now breaking even and you are showing a profit. You know, but profit isn't the most important measure of a law firm's success. The most important measure, especially for a solo practice, is what we call ODI, owner's discretionary income. In plain English, how much money do you need to take out of the practice in order to live? That is a question that I think no two attorneys will have exactly the same answer to that, but you need to have a sense of what that is. If you desperately need to have $100,000 a year to be able to get $100,000 a year out of this practice to live on, that's going to dictate certain lifestyle choices that someone who only needs $25,000 in ODI doesn't have to deal with. So these are difficult questions. But once you know how much ODI you need and what your costs are, then you know how much money you have to make each month to break even. Most solo law practices break even fairly early. The good news or the bad news is that there aren't a lot of fixed and variable costs involved in a solo law practice. Everything goes to our bottom line. There's only so many law books that I can buy. There's only so many conferences I can attend. And most of them I'm doing for free. I do for free because I'm speaking at them most of the time. You know, that's good in a way. It means that I break even when I first started out 26 years ago in my home practice, I broke even the first month. But the bad news is, of course, is I don't have enough deductions for taxes. Everything goes to my bottom line. So my tax liability is probably a lot bigger than some other people who have businesses with employees and real estate where there's a lot more deductible expenses involved. I have trouble getting deductions in a solo practice. And if you find any creative ways to get good tax deductions, please share them with me. I'm all ears. Don't forget, speaking of taxes, don't forget about taxes. The biggest mistake that people make when they start working on their own and they become an entrepreneur or a self-employed professional or a solo lawyer, they forget that they have to withhold taxes from their paychecks. When you work for somebody else, all of that gets done by your HR department. You know, they withhold your the FICA, the Social Security taxes, the Medicare tax. All that gets, you know, withdrawn, get withheld from your taxes by somebody else. When you start practicing on your own, though, you are the one who have to withhold those taxes from your own income, and you have to pay them, the IRS 4 times a year, and the state of New York 4 times a year, paying what we call estimated taxes. On April 15th, June 15th, September 15th, and January 15th, you have to pay your estimated taxes for the preceding quarter. And it's an art, not a science. Let me tell you right now, what you have to kind of do is do a mini tax return for that 3 or 4 month period, figure out how much money you made and pay the IRS accordingly, and then hope to God you can clean it up at the end of the year if you made a mistake. You know, whenever you are in any kind of a solo business, you have to escrow for taxes. I personally escrow 35% of everything I make. Every month I look at how much what my gross income is. I take 35% of it and I put it into a separate interest-bearing account, which I call my escrow account, and I do not touch it. I do not touch that money. When a tax payment date becomes due, what I do is I look at the escrow account. I write the check to the IRS out of that. Whatever's still in the account, I keep it to the next quarter. If I turn out to be a little bit, if I owe the IRS a little bit more than what is at the in the account at that time, I take more money from the operating account and put it into the escrow account, and I pay the the IRS out of that. Whenever you are working for yourself, you cannot live on 100% of what you make. You can only live on 2/3 to 3/4 of what you make. How much depends on your tax bracket and how many deductions you have. If you've got 10 kids, obviously you don't have to do escrow as much as someone with no kids has. But make sure you escrow for taxes. One of the dumbest things you can do when you run a solo practice is to get to a tax payment date and you don't have enough money to pay the IRS with. And if you find yourself in that horrible situation, then there are only two things you can do, and they're both stupid. Either you underpay the IRS and hope to God that you can make it up on the next quarter, which you may or may not be able to do. Or that's stupid thing number one. Stupid thing number two is you borrow money to pay the taxes at credit card interest rates. Those are two very stupid things. Escrow for taxes. It's very, very important when doing your financial planning that you can only live on 2/3 to 3/4 of what your clients are paying you, not 100%. Okay. Let's talk about your marketing plan. Let's talk about marketing. I know I'm joking. What I'm really doing here is I'm giving you an executive summary of what we cover in these are all, each one of my slides is a 50-minute segment on the Starting a Solo Practice program that we do for the State Bar. Carol Shiro Greenwald is one of my best friends within the New York State Bar. She is the marketing speaker for Starting a Solo Practice, and she's also written several very good books for the New York State Bar on marketing a solo practice. So you definitely want to check those out. They're all wonderful. She writes in plain English. She is a lawyer herself, but she's also a PhD. So she actually knows how to write English. And the books are very entertaining. Here are the five. One of the handouts that I've given you is what I call the 5 pillars of a solo practice marketing plan. There are 5 areas in which you have to focus your marketing strategy when you're starting a solo practice. Number 1, your firm name, address, business cards, and stationery. Number 2, your involvement in organizations and community activities, the networking that you do with other people. Number 3, your personal interaction with potential clients and referral sources, your elevator pitch. What that is, that's an elevator pitch is like a 15 or 20-second description of what you do. So someone approaches you at a cocktail party and says, "Hey, Cliff, what do you do?" Out pops your elevator pitch, and you explain what can you say to this person in 15, 20 seconds that will make them, the amount of time that an elevator would drop to a floor of an office building. That's why it's called an elevator pitch. You get on the elevator with somebody, you start talking to them. Takes what, 15, 20 seconds for an elevator to go down to the ground floor. What could you say to that person in 15, 20 minutes to get them interested in what you do and want to know more about you? Number 4, your public speaking strategy. I have used this to great advantage. I love speaking publicly. I'm a ham. I admit it. I'm a failed actor or stand-up comedian. I know I just made a bad career choice, and I'm trying to make the best of it, folks. But I love speaking in front of groups, and that has done very, very well for me. When people looking for attorneys, they're not looking for an attorney, they're looking for you. They want to see what you are all about. Can they relate to you? Do they feel they can work with you? This is what they want to know. You have to humanize. People are afraid of lawyers. You have to humanize yourself and say, "Hey, you got a problem with the IRS? Great. I'm not going to judge you. That's what I do. I'd love to help you solve your problem. Come on in. We'll get through this together, and don't worry, you won't go to jail for too long." And then last but not least, your law firm website, your LinkedIn profile, your directory listings, the things that you put out there to attract business to you. There are rules of ethics that apply here. The Articles 7.1 to 7.5 cover attorney advertising, but don't let the rules of ethics stop you from marketing. If there's one thing you come away from this segment with, it's success in a small business depends almost 100% on how well you market yourself. If you market yourself well, you stand a very good chance of success. If you market yourself poorly, you will fail. It is 100% guarantee. For more on the 5 pillars of a solo practice marketing plan, look at the handout that I gave you on that. Okay. What are some of the things that a solo practitioner needs to be successful? Well, you have to have at least one client. A law practice without a client isn't really a business at all. It's more of a hobby. A virtual library. Cliff Ennico says a law book without forms and checklists is worthless. Legal treatises on the law are worthless. You can get most of that information on the internet now. What you need are tools. You need forms. You need, if someone asks you to do a frugal framus agreement, you want to look at least 2 or 3 forms of framus agreement, compare them side by side, figure out what the standard provisions are and what's negotiated, and be able to satisfy that client's needs. These are some of the major law book publishers. Bookmark their catalog pages, find out what they've got. There are also some excellent websites now with some very, very good legal forms. The best is the SEC Edgar database. A lot of people don't know this. When they think of the Edgar database, they think of like S1 registration statements and all that. But what people don't realize is that when someone does an SEC filing, they also file all of the what they call the ancillary documents, the exhibit documents that go with that registration statement. So if you're looking for a form of merger and acquisition agreement, the best ones are attached as exhibits to SEC filings, and you can get that publicly. It's absolutely free. You can download those things for nothing, even as a Word file. That's absolutely free. There are some other websites where you have to pay for downloads. I mean, to my mind, the best of these is a website called uslegalforms.com. But there are others. There are plenty of others, not the rocket lawyers and the ones, those are like Bloomberg forms. You want forms that have actually coming from attorneys and that were actually used in real situations. So when you look for legal forms online, you're probably not going to get them for nothing. Unless they're coming from the SEC's Edgar database. Look at the websites where you have to pay a few bucks for each download. You need a dedicated, the best malpractice insurance you can afford. That is essential. A dedicated computer with multiple backups, very important. I back up things 3 times. Okay, I back up. I back up. I have Microsoft Office 365. As part of that, you get Microsoft OneDrive, which is their cloud solution. Everything that I do every hour on the hour gets backed up to OneDrive, on my computer. I also have a cloud backup solution that I pay for. It's called iCloud.com. There's a bunch of these. Costs about $20 a month. Well worth it. Again, you program your computer every couple of hours. It backs up to iCloud. So now I've got all my documents in 2 different places. And then once a month, I have an external hard drive. You can get these on eBay for about $25-30. It actually looks like an old floppy disk drive. You actually plug it into your USB port. You download your entire computer onto the hard drive every 30 days and you unplug it. So now your data is in 3 different places. It's in OneDrive, it's on iCloud, and it's on an external hard drive. There is no way, if you ever do become a victim of a cyber attack or a phishing attack, there is no way that you'll not have access to your data if you're disciplined about backing up on a regular basis. It's the most important thing about computers, I can tell you. We are going to have a great speaker, by the way. The IT guy at Littler Mendelsohn is going to be speaking on the June 7th program about things you have to do with computers in a home office. And last but not least, a network of other attorneys that you can bounce questions off of. Okay, there's no such thing as a solo practice that operates alone. I have a network of 5 or 6 attorneys. We're all very close friends. We support each other. We're in different areas of practice. We don't really compete with each other, but if one of us has a question, I know that I can call one of these people and they will take 15-20 minutes out of their busy day and sort of help me walk through whatever problem it is I'm having with a particular client or whatever. Develop a little virtual network of attorneys. I'm not saying you have to refer business to each other. This is why you attend bar associations, is to meetings is to find these people. Look at some of the other people who are on this call. They're in exactly the same situation that you do. They're wrestling with some of the same issues. Make friends with them. Develop a network. To start developing a network of people. Whenever you get stuck on something and you need an answer quickly, don't look for a book. Look for a person. And find somebody who can help you answer those questions. Okay, here's my second pop quiz. What famous marketing expert, we just talked about marketing, said you can make more friends in 2 months by becoming interested in other people than you can in 2 years by trying to get other people interested in you? Who was it? Very one of the most famous marketing experts who ever lived. All right. Let's talk a little bit about how to grow your practice. So now you've started your practice, you got a few clients, you want to get it off the ground. Okay, should you hire an associate? The basic 3-to-1 rule that applied when I was back in law school still applies today. Whenever you're looking to hire an associate, the total cost, or an employee, the total cost of that employee is 3 times the person's base salary. Once to cover their base salary, another to cover their overhead and benefits, and the third profit, which goes to the firm. If you do not have enough business, if there isn't enough work to cover 3 times the associate's base salary, you probably shouldn't hire that person. You continue doing the work yourself until there's enough work to justify that expense. Outsourcing, there are firms out there where you can outsource work that will help you find a temporary attorney to help you with a particular problem, to fill in a hearing date for you or something like that. There are some firms that are out there. They frankly speak at our starting, some of their representatives speak at our starting your solo practice segment. Should you volunteer to be an outsource for some other attorney who needs someone to cover they need someone to cover a hearing in New York for one day? Creating a virtual law firm. A couple of years ago, the New York City Bar came out with an opinion, very good opinion, 2020-1, going into the ethical implications of having a virtual firm where several home-based attorneys get together and start sharing stuff. But just be careful whenever you grow a practice. Rule 84.4G says that you cannot discriminate. If you're hiring, you are subject to all the federal and state anti-discrimination laws. You can't avoid those by saying that you're an attorney. And then last but not least is exit strategy. How do you get out of the practice if things just, when it's time to retire, or if things don't work out? What happens in your clients and pending matters if you die or become disabled? Here's, I guess, you're not going to get a lot of money for your law practice. You're not. Why? Because you cannot sell people. You cannot sell clients. You cannot sell customers. I mean, I've got 20,000 people in my client database, but how many of them are working with me at a given time? And, when I do, a lot of them work with me because I'm me. If I sell to somebody else, half these people are going to go elsewhere. And I do not know which half are going to go elsewhere. So in general, when you sell a law practice, you do what's called a royalty deal. You get a little bit of money up front, usually is $20,000, $30,000, sometimes even less. But then what you do is you get a percentage of whatever the buyer gets off of your client list for a period of 3 to 5 years. So, so for example, if I was selling my practice, I'd probably get about 25, 30,000 up front. And I would get, I would actually hand over, my client list, as a CD-ROM to the buyer, and whatever that buyer gets off of that CD-ROM for the next 3 to 5 years, I would get maybe 20, 25% of it on a monthly basis. And that's how I would be compensated. Also, buy a tail malpractice policy. Very important. But keep in mind, though, there's a very big thing. Once you buy a tail policy, the tail policy basically covers you for anything that you did up to the day you retired, and it lasts forever. If I buy a tail policy today and I get sued 20 years from now because of something I did 5 years ago, the tail policy will be there and it will cover me. It's a great thing to have. If you stick with the same malpractice insurer for several years, they'll give it to you for nothing, which is nice. But there's one big caveat here, and that is when you retire and you take out a tail policy, you cannot practice law ever again. You are not allowed to do. If you do, well, you can, but you're not covered by insurance at that point. A tail policy only covers you up to your retirement date. So you can write books, you can participate in bar activities, you can maybe teach, but the minute you take on a client after you retire, you are naked. You are not covered if you have a tail policy in place. That's a very major catch-22 for retiring lawyers. I really hope that the state bar does something to change this eventually after a while. So for example, if I want to retire tomorrow, but I want to mentor some of you younger attorneys, I cannot do it because of the malpractice risk involved. That is something that needs to change, especially if we want older attorneys to mentor younger ones. Okay, we're almost done. Here is your MCLE verification code. It's P as in practice. You may notice, by the way, that these letters often have something to do with the title of the program. That's something I'm kind of picking up on here. P as in practice, P as in profession, P as in what the 16th letter of the alphabet. Okay, there's your verification code. Let's just talk a little bit about billing and collection, and then I'm going to shift gears a little bit and talk about something else, that's not involving. This is one of my favorite topics. By the way, your third handout, by the way, that I've given you is an article that I wrote a couple of years ago, which is becoming probably one of the most popular things I've written. It's been downloaded now for over 1 million times from some of my from a couple of my websites. Now it's called 25 Rules for Having a Successful Solo Practice. Follow these 25 rules, print this thing out, put these, each one is a sentence long. Print this out, put it up on your computer, read it every day, and I guarantee you will have a successful practice. That's another one of the great tools that I've given you in the handouts section. Okay, bill early and often. I had a landscaper for years. I loved this guy, did a great job on my lawn. The problem is he would never send me a bill. I would beg him, send me a bill, please. I got money this month. I can pay you. Pay me, send me a bill. He never did. What he did was he waited until the season was over. A week before Christmas, he would send me a bill for the entire year, $15,000 payable upon receipt. And it drove me freaking nuts because, a week before Christmas to get a bill like that, payable upon receipt, I actually ended up firing him because of this. I couldn't take it anymore. I said, if you can't pay me a month, send me a monthly bill, I am not going to hire you. Clients are much more likely to pay frequent small bills than a single massive one. Always, always, always get money up front, especially from a client you do not know. Never, ever, ever send a client a bill they are not expecting. The surest way to get a client angry with you, angry to the point of filing a grievance against you, is to send them a bill they are not expecting. You told them it was going to be $200. You send them a bill for $800. That client is going to hate you. Do not do that. Communicate with your client, let them know, if you find yourself going over what you originally estimated, talk to the client, get their buy-in to the additional fee. Take time to discuss bills with your clients. Never send a client a surprise bill. It's the surest way to it, and one of the surest ways to an ethical grievance that I can think of. If you did spend so much time on a project, give the client a courtesy reduction. Every once in a while, I do this. I say to myself, I spent $1,000, but really, I can't bill that. That was only a $700 job. Rather than just billing the $700, I bill the $1,000, but then I give a courtesy deduction of $300. And to get to the same, clients do not question your bill when you do stuff like that. There's a whole science of billing. I really need to do a whole 50-second segment on how to bill clients. But these are the basic rules. I do have a YouTube channel, by the way, for those of you are interested. These do not qualify for MCLE credits. I have to tell you that, but I've got 52 one-hour videos up on YouTube for people who are starting a small business or a tech startup or who want to become entrepreneurs. They're on all different topics. If you go to youtube.com and search for Cliff Ennico, my name, just like it appears there, you'll see all 52. Some of them are very entertaining. I'm accused of having a sense of humor and being a failed stand-up comedian. But some of these, and I have a very good one on client management, on how to deal with clients. And it's not just for lawyers, it's for any service professional. Go to YouTube and search for Cliff Ennico Client Handling. It's about an hour long. And I basically cover the 25 rules that I talk about in my handout. Okay, here's my last pop quiz. Some of you may remember this. It's for you movie buffs out there. In what famous movie does a down on his luck solo attorney market his practice by attending strangers' funerals and handing out his business card at strangers' funerals. Obviously not a recommended best practice. Name the movie, and if you can, name the actor. Again, send it to my email. Do not send it to the chat room. The first and best answer to the question gets the book. So here are some final thoughts for you. And I guess the most important thing here is start managing, thinking of your practice as a business. Take an entrepreneurial tack to your business, and especially learn how to market, learn how to sell. That is the most important thing in any small business's success. If you market yourself successfully, you will succeed. Don't do it well, you will almost certainly fail. Here are some of my books, by the way. The reason, by the way, I know that I practiced in 36 different areas of the law, that book on the right, The Advising Small Businesses, is basically a 36-chapter treatise. Each chapter is a different area of the law, just what you need to know to represent a small business or an entrepreneurial startup. That's why I know that I practice in 36 areas of the law. I'm adding a 37th chapter next year in 2023. The other book, the one on the left, Forms for Small Business Entities, this is my personal form file. Whenever I do something, a contract or an agreement or a form for a client that I've never done before, I take out the client names and any personal information, and it goes into this treatise. If my house were ever on fire, this is the one book I would want to make sure I leave the house with. Okay, these are some of my Small Business Survival Guide is more of a general collection of stories. Again, if you're really interested in my books, there's the link to the website. You can find out about this. This is me, and where you can find me. I have a few minutes left, and I don't want to spend them talking about starting a solo practice. I want to talk about something more important, which is your future at this point. Now, some of you are younger, some of you are older, but I said at the very beginning of this segment, I've been practicing law now for 42 years. It's hard to believe 42 years goes by like that. I'm looking, what's the old joke? Inside every 60 something guy, there's a 20 something guy saying, what the hell happened? And I'm definitely in that mode. I can't believe it's been 42 years since I've been sworn into the second department in Brooklyn. But there are two things that I can say about my career and my life, and I hope you'll find them helpful. Thing number one is that I am not doing today anything that I was doing for my clients back in 1980 when I first got started. I'm not doing anything. In fact, I'll take it a step further. Most of the things that I do for my clients today as a lawyer did not exist in the year 1980 when I was first admitted to the bar. LLCs, limited liability companies, they didn't exist in 1980. They were only adopted in the early 1990s. New York didn't adopt its statute till 1994. Back then it was all corporations and partnerships, believe it or not. I haven't done a partnership in only over 20 years because everything's now LLCs. Things change. Computer law, well, maybe in 1980 there were one or two attorneys in Silicon Valley that were doing that. Now we're all computer lawyers. Look how we're doing this program today. We have to be competent in technology just to survive. We're all to some extent tech lawyers. Now, internet, e-commerce, eBay, Amazon, none of the cybersecurity, none of this existed in 1980. We were still using 8.5 by 14 legal pads back then. Things change. The key to surviving in a solo law practice is to be adaptable, be prepared to change. Things come along, don't say no to them because, oh, I'm a real estate lawyer, I don't know if I can do that. Whenever a client says, I need you to do a frugal premise agreement, and it's something you kind of know what it is, but you're not really intimately familiar with it, your mind should say, this is an opportunity, Cliff. This is how your clients are telling you what they're going to be needing next year, 3 years from now, 5 years from now. And now is the time to get on board, learn how to do it, and figure out how to solve that problem. Because if you do, you will be the attorney that will get all of this business. Because if they're needing a frugal premise agreement, chances are there are a lot of other clients out there similarly situated who are looking for a frugal premise agreement. If you know how to do a frugal premise agreement, you will get all of that business. That's how your marketing brain has to work. I can't tell you how many times a client has called me and said, hey, Cliff, I need you to do a certain type of agreement for me. I figured I spent a couple of late nights. I read some stuff. I put together some forms. I did the thing. And now all of a sudden they're referring me to 3 of their friends saying, hey, this guy Ennico, he knows how to do this. Call them. This is how you get business, and this is how you grow as an attorney and as a professional. Like I say, I'm not doing anything for my clients that I was doing back then. I had to learn as I go along. That's the first thing I want to tell you. The second thing I want to tell you is a little tougher to talk about, and that is those of you who were younger, you are going to have a challenge that my generation did not have in building a solo practice. You know, let's put it that whenever you try to predict the future, you end up putting your foot in your mouth. And I'm sure I'm going to do exactly the same. But here's a prediction I feel very confident about. In 40 years from now, okay, when I'm slipping porridge in a nursing home somewhere, okay, and you look like I do today, 40 years from now, most of the things that we attorneys do for our clients today are not going to be done by attorneys or human beings at all. They are going to be done by software, bots, artificial intelligence, algorithms, call them what you will, but machines are going to do a lot of what attorneys today are doing for their clients. So if you're looking to build a successful solo practice, you have the same challenge that I had of keeping on top of things, keeping on top of developments in the law, new fields of technology, new legal needs that people have, new potential markets for legal services. You have the same challenges that I had, but you have an additional challenge. You have to stay one step ahead of the machines. Okay, because if you're a real estate lawyer and all you are doing is residential real estate closings, I got bad news for you. You are going to be obsolete in 5 years. There are states already, Missouri is one that I can think of, where you don't need an attorney to do a real estate closing. The brokers all do things with electronic forms, and they exchange things via DocuSign. And this is, no attorney ever touches those documents. This is where the world is going. If you want to be a successful real estate lawyer 40 years from now, you got to figure out what services are not going to be automated so that you stay one step ahead of the bots. I wish I had good advice for you on how to do that. I really don't. But it's important to point out, because this is a big challenge you have that my generation did not have. So that's really all I have to say about starting a solo practice. Congratulations, you are done. You have succeeded. You have bridged the gap. This is the last thing I want to leave you with. It's kind of my personal motto. This is what's going to go on my tombstone at some point. It's the guiding principle by which I have built my practice over 42 years. Never let a lack of knowledge, experience, or talent get in the way of your success. By all means, practice ethically, practice responsibility, practice, professionally, but don't let the rules get in the way of doing what you need to do in order to build a successful business. This is the rule that I have lived by. It has never stopped me from learning how to do new things. Don't let the rules become a prison. Learn new things, develop, grow, continue to be adaptable. Evolution, the only species that survive are the ones that adapt. You're the ones, learn how to adapt, and don't let anything get in the way of your success. In fact, here's another prediction. By following this rule to the letter, there's a very good chance that someday you may end up being president. That's it. You've now successfully bridged the gap. Thank you very much for listening for me. I don't see that we have a lot of questions. So Kathy, I'm going to just turn the floor back to you.
And thank you again to Cliff Ennico for doing a great job of closing out our Bridging the Gap program. Just a reminder, for all of you, please be sure to submit your MCLE verification codes to the learning dashboard. Give it a few moments before you hit submit. Until I actually close the program, it's not going to say that you were on here for the entire duration. So I will close the program and stop the recording in just a minute or two. Just a reminder, please be sure to complete the program evaluation form. And just a reminder, yesterday's closing segment for intellectual property did carry 2 credits. So there were 2 codes for yesterday's day 1 closing segment. So I know there were some questions coming in to the chat about that. If you don't have it, and if you have an issue with it, the archive will be posted for everyone to review tomorrow. And then you can also fill out the MCLE form and submit it directly to a registrar if you did not do the program in its entirety. If you listened to it by part or if you skipped a session, you have to submit directly to our registrar. You won't be able to use the learning dashboard. So it is 4:30. I am going to stop the recording. And please be sure to go to the learning dashboard to submit your MCLE forms. On behalf of the Bar Association, thank you for attending our Bridging the Gap program. We will have the June dates upcoming, and we'll be scheduling for July and August as well. Thank you again. Okay, so Cliff,